One of the issues that Kenyans or anyone following the Kenyan cases in the ICC needs to understand is that every decision lies with the judges. What the ASP did was just pronounce itself to the decision of 2013 of the Assembly of State Parties then. So this year, they just pronounced themselves and said, we want to clarify that this particular rule was not supposed to be used retroactively, which is what Kenyans wanted, the Kenyan delegation wanted. And so, if the judges, the appeals chamber, which is dealing with the appeal by Ruto and Sang, if they decide to go with the ASP, or rather with the political wing of the court, which is the ASP, what just said, this means that Bensouda, as she has said, these 5 statements are critical to her case. So, we would have a situation where probably her case would weaken, or would have a situation where the judges, if the appeal judges decide that, yes, you can't use it retroactively, and decide to send this issue back to the trial judges as they did in the Uhuru case in terms of in the issue of cooperation. Bensouda is not making new allegations. She's not saying I have new evidence against Ruto and Sang. What basically Bensouda is saying is that Ruto and Sang filed a no case to answer motion where they want the cases terminated before they get to the defense part of making submissions or giving their evidence. And so, after the filing that they had done in October, Bensouda had a period, about a month, to respond to the issues. And so she did, actually a week ago. And so, what Bensouda is saying, she's trying to contradict the arguments given by Ruto and Sang. For instance, she goes to where Ruto and Sang, Ruto says the Kiambaa killings were never linked to me. She says, no, I have the evidence that the Kiambaa killings were committed by Kalenjin youths who were recruited and financed and sent out by Ruto's alleged associates. And so she says this has a link to Ruto directly. And so that's what she's saying. All what she's presenting in her response to the no case to answer motions by Ruto and Sang is what is already in evidence before the court. The arguments by the lawyers have been that if you use these cases against our clients, they will not have the benefit of cross-examining these witnesses. And they have given an example, which is, I think it's common knowledge, that there is one witness, one of the statements belongs to a witness who never appeared in court, who the defense never got to cross-examine, a situation where even the prosecution itself did not examine this witness because the witness never appeared. So how do you use a statement which this particular person has said, this statement was false, I was made to do it, and I'm not coming even to tell you my new side of the story. So first and foremost, the reliability of that particular statement is null from the start. So it's a situation where I think it would not be fair to use such kind of statements against Ruto and Sang.